My name is Stephen Bruce, and I'm the Executive Director and founder of the People with Disabilities Foundation, which was founded year before last with a goal of integrating disabled persons into the whole of society through advocacy and education. The name of this program is Social Security Disability Work Incentive Programs. We had a seminar of the same name on July 12, 2001, and now we are updating it in a condensed audio version. Present on the panel today is Calvin G., who has been with the Social Security Administration for 28 years, the past 2.5 years as a Director of Public Relations for the Greater Bay Area. We are also pleased to have Marilyn Reiss, who has been working for Social Security for 28 years as a claims representative, operations supervisor, and now a PASS specialist. Also on our panel, we are pleased to have Mike Mundy, who has worked for the Los Angeles County Department of Public Social Services. He was hired by Social Security in 1978. My background includes having been a senior attorney for the Social Security Administration's Office of Hearings and Appeals, having been a supervisor of government benefits in a legal aid office, and since 1991, having managed a private Social Security disability practice for approximately 9 to 10 years. The People with Disabilities Foundation produces this program as a public resource containing general information which is intended to, but not promised or guaranteed to be correct and current. Do not rely on information in place of the advice of competent counsel. The Social Security Administration has provided speakers for the panel. The information that they are providing for this program is meant only as a public resource containing general information which is intended but not promised or guaranteed to be correct and current. Do not rely on this information. For further information, you may contact their website at ssa.gov or call their toll-free number at 1-800-772-1213 or visit your local Social Security office. The Social Security Administration administers two separate disability programs. One is commonly known as SSDI, or Title II. This disability program is for people who have insured status under the Social Security Act, which generally means that they have worked 20 out of the last 40 quarters, or approximately 5 out of the last 10 years. There are no income or resource eligibility requirements to receive disability checks and Medicare under SSDI. The other program administered by the Social Security Administration is SSI, also known as Title 16 of the Social Security Act. SSI is the poverty program, with both income and resource eligibility requirements. Although the standard for disability is pretty much the same as for SSDI, there are income and resource eligibility requirements that must be met in order to continue receiving SSI checks and Medicaid. The resource limitation for one person is $2,000, and for two people, it's $3,000. In this program, we will be discussing disability work incentive programs. However, they are not the same for SSI as for SSDI. I'm now going to turn over the mic to Marilyn Reiss, who will discuss the work incentive program for people who are receiving Social Security disability benefits under Title II or SSDI.
There are two distinctly different programs, Social Security, SSDI, and SSI, and what I'm going to be talking about refers only to SSDI. The work incentives for the two programs are quite different. There are a few things they have in common, but basically they are different. So if you receive only SSI, then you probably don't even want to listen to this portion. It might be confusing, and if you receive both, remember that what we're going to be talking about at this point only refers to the SSDI. The Social Security work incentives or employment supports are intended to help people enter or re-enter the workforce while protecting their cash or medical benefits until they have reached their work goal. So it allows people to try to go to work and not risk losing their benefits right away, or actually now over a long period of time. So So the question is, if you're receiving SSDI and you go to work, what happens? What's the first thing that happens? And the first of the work incentives is the trial work period. That allows you to work for 9 months, earning any amount of money and still receive your benefits. Now, for a month to count in the trial work period, you have to be earning at least $560 a month. If you're self-employed, it's possible to also have a month in the trial work period if you're working at least 80 hours a month in your business. But if you're earning less than $560 and or working less than 80 hours in self-employment, that doesn't even count as a month in the trial work period. The 9 months for the trial work period do not have to be consecutive. It's a total of 9 months in a rolling 60-month period. So during that 9-month trial work period, you do not lose your benefits no matter how much you earn. And if you stop working during that time, there's nothing to be reinstated. Your benefits should continue. When you begin working, though, you should notify Social Security that you have started working. Then the next step is what happens once the 9-month trial work period has ended.
You mentioned the self-employed rules, or at least one of them. Mm-hmm. Could you tell us a little more clarification how it works? Just the trial work period for people who are self-employed, how are the dollar amounts that they're allowed to make calculated without going into great detail? And are they averaged, or how do we figure that out? How do they know?
Self-employment is always figured on a yearly basis, so that we use the net income for the year and divide it by 12. And in those months in which the person is performing services in their business, those would be the months that would count in the trial work period, and the amount of income would be based on their yearly total. But again, they may not be making $560 or averaging $560 a month, but if they're working at least 80 hours in the business, that is considered a month in the trial work period.
And what if they're working over 80 hours 1 month, or at least 6 months, and then skip a few months because for whatever reason, do we still average over the whole year?
They have to be performing services in their business for it to be considered as a trial work month. So if they're working in the business and making $560 a month, then they would normally be considered a month in the trial work period. But I should say, in terms of the trial work period and the next step we're going to talk about, the extended period of eligibility, self-employment is probably the most complicated and not as black and white as working for wages. And so I would definitely encourage anybody who is self-employed to talk to a representative, Social Security claims representative in their local office who's knowledgeable about the trial work period.
Would there be any person in particular that they should ask for? I mean, should they ask if anyone in particular specializes in self-employment for disabled people?
Well, generally there's not anybody that would be that specialized, but usually most offices do have somebody that is more knowledgeable about the work incentives, and definitely they would want to talk to a Social Security claims representative to start with. Once the trial work period is completed, as I said, the next stage is the extended period of eligibility, and we'll use EPE to abbreviate that. The extended period of eligibility begins the month after the trial work period ends, and it goes for 36 consecutive months. And during that time, benefits can stop if the person is earning over $780 a month, which is called substantial gainful activity. It's SGA. And that amount changes, as does the amount for the trial work month each year based on the average national wage. So it goes up a little bit, but not too much. So this year, for people who are not blind, the amount is $780. For people who are statutorily blind, $1,300 is the amount for SGA. So any month, once the trial work period is over, that a person earns over those amounts, they will not be entitled to an SSDI check. Again, for self-employment, there are some other rules because you may be earning less than that, but if your work is comparable to an unimpaired person doing the same work, or if the actual services you're rendering are worth over $780, that also could be considered as doing SGA.
Marilyn, you said SGA a couple of times, which is an important concept, at least in the Social Security disability area, and it of course means substantial gainful activity. Now, if someone, as you just said, makes over the SGA amount, which currently is $780 a month, is that a presumptive amount? In other words, they just don't get their check, or is there another step that comes after the 780?
Well, there are some ways that the 780 can be reduced. I want to go back one step just to mention that the self-employment rules for SGA do not apply to people who are blind. If a person's receiving Social Security as being blind, they either are over the $1,300 or they're under. If they're self-employed, we don't look at is their work comparable or what is it worth. So just so people know that additional rules for self-employment only apply to people receiving benefits as not blind. But yes, there are some rules where if a person is earning over the $780 or $1,300, where actually it could be considered less. One of those is by what we call subsidy or special conditions. And that's generally where a person might have easier, fewer duties, additional help, additional supervision. It's additional help that's provided by the employer. And if the individual believes that they are receiving this help, and we generally will ask that question, but certainly if they're not asked that, they should bring that up. Then we will usually contact the employer, and the value of that additional help would be deducted from what they're receiving. So someone who's earning $1,000 a month, but really is only working 3/4 of the hours that they're getting paid for, and their employer is just being nice and letting them take a lot of extra breaks, might only be considered as earning $750 a month, and therefore would be under the SGA limit.
Marilyn, it sounds like that the subsidy amounts are used or can be used instead of the word accommodations, which we use in the employment area. In other words, if the employee provides an accommodation, whether legally required to do so or not, giving the breaks or providing an interpreter for someone who's hearing impaired, are they synonyms? Are we talking about the same thing?
Not necessarily, because a person that's receiving accommodations, it may or may not be fully earning their pay, but it could be the same thing. Again, it's something that needs to be discussed with the employer and determine whether the person is really earning their pay. It has more to do with what would somebody be earning if they weren't getting this extra help. But it is possible that what is also considered an accommodation could be subsidy too. Okay, the other way that wages might be reduced below SGA is what's called impairment-related work expense, and we abbreviate that by calling that an IRWE. And that is a concept that is common to both SSDI that I'm talking about and SSI that you'll be hearing about later. And the definition of an IRWE is the same for both programs, but it is applied differently. What an IRWE is, an impairment-related work expense, is basically just that. It's an expense that an individual has that is related to their disability that is required in order for them to work. It could be an expense that they would have even if they weren't working, but it is something that they need in order to work and that they have as a result of their disability. It is an expense that they pay for themselves and that they're not reimbursed for. So it's an out-of-pocket expense that they have. And it could be something like medications that an individual has to take in order to work and that their insurance or Medi-Cal does not cover. It could be unusual transportation expenses over and above regular driving or public transportation. Job coaches are considered an IRWE, and there are some other things, but those are the most common. So if a person has that expense, that is deducted from the income that we're counting. And again, someone who's earning $1,000 a month but has $300 in medications that they have to pay for each month, though if those medications are related to their disability, those could be deducted and would put them under the $780 SGA limit. So those are two ways that wages could be reduced under the limit.
If someone was receiving extra supervision, would that be considered an impairment-related work expense or a subsidy?
If they're paying for it themselves, like a job coach, then it would be an IRWI. But if the employer
pays,
then it's a subsidy. Right.
Okay, thank you.
During this 36-month extended period of eligibility, a person can go back and forth between being eligible and ineligible for benefits. So any month where they're earning over or determined to be doing SGA, once we look at earnings and other factors, they would not be eligible for benefits. And the next month, if they go below that amount, they could become eligible again without any new applications, basically just letting the local Social Security office know that they're now under that amount. So during that 36-month period, it's easy to go back and forth between being eligible and not eligible. It's just a matter of reporting it to your local office. There also, during that period of time, the first month, there is a grace period, and so that the first month that a person is doing SGA and the 2 months immediately after that, they actually would still receive their benefits. So there is a 3-month grace period. The next thing then, after the end of the 36 months, what happens after that? And generally, in the past, once a person was doing over SGA and the 36 months ended, their benefits, they would not be receiving benefits, and if they had to stop working later on, they would have to file a new application and go through the whole application process. There's new legislation, and you're going to hear much more details about that later, the Ticket to Work legislation, and part of that was the expedited reinstatement, which makes it much easier to go back on benefits if work ends or goes below SGA within 5 years of benefits being terminated. And if that is due to the same or a related impairment as that which you were originally eligible for. A new application is needed, but it's a much shorter application, and you can receive provisional benefits for 6 months while the determination is being made. So that makes it a lot easier to go back on benefits at that point, and you'll hear more about that, as I said, later
Marilyn,
on.
how long does it take to get the determination? In other words, you get the benefits for 6 months when you're reinstated within 5 years, if it's the same or related impairment. But normally, and I'm just going to use an average, could take a year or 2 years to get through it if it has to go through an administrative law judge hearing. What happens, I mean, if the 6 months is up and they're still trying to determine?
Well, generally, with an expedited reinstatement case, that's not going to need to happen. I don't have any numbers at all as to how many there have been or how many have been reinstated immediately, but usually because we're looking at the same impairment and just looking at improvement, whether there's been improvement, it's not as likely that it will need to go through the appeal process, but if it did, my understanding
Are their
is...
checks cut off if the judge, the 6 months are gone and they're
Right.
asking for a hearing before a judge, the checks are cut off, but in no event can that money they receive then be used as an overpayment.
That's correct.
In other words, the administration will not demand they repay the money.
Right.
Even though it will be cut off regardless
That's correct.
of a determination.
Right.
Thank you.
Now, the other thing that people are most concerned about, usually sometimes more than the cash benefits, is medical benefits. And Medicare is something that people receive once they've been on Social Security disability for 2 years. And there have been some changes also improving the length of time that Medicare can be received. Currently, with the new rules, you would continue to receive Medicare for 57 months after the extended period of eligibility ends. So a total of 93 months from the first month of the EPE. And this would increase the old rules by 54 months. There are a few cases for people whose EPE started a long time ago where they might not qualify for this, but if the EPE began after June of '97, you're always going to be entitled to that. If it began before that, it gets a little bit more complicated and definitely would need to speak to your local office. Even at the end of that period, there's provisions for buying Medicare and sometimes at a reduced rate. So the medical benefits are protected for quite a long period of time, and oftentimes by that period the person may be receiving medical benefits through their employer, but if not, they can continue to pay for the Medicare.
So you say 93 months, which is, you talked about the extended period of eligibility, or EPE, which is 36 months, and now we're adding, is it
57 more months.
57 more months. And this is the period of time, you're adding 57 months, or about 4.5 years, and this is the period of time that they can still be eligible for Medicare, or can they also receive the checks, the money?
No, just Medicare. The checks, if they're working and doing SGA, if they're not doing SGA, if their benefits haven't stopped, then they're going to still receive their money. But if their benefits have stopped because their extended period of eligibility, EPE, has ended, and they were doing SGA at that period of time, but they can still be getting their Medicare.
Even if, as you mentioned, the employer is offering their own insurance, they can keep their Medicare if they want?
If they want to, yes.
They don't have to elect?
No.
Okay, thank you.
Now, all the rules that I've been talking about are with the understanding that there has been no medical improvement, or not enough to the point where the individual is no longer considered disabled. If there's been medical improvement, then these rules don't apply, and we will continue to do medical reviews in most cases. But there is one provision, and this applies to both Social Security, SSDI, and to SSI, where there can be medical improvement and benefits can continue. And that's for those individuals who are in an approved vocational rehabilitation program, and it's determined that they would benefit from continuing that program until it's concluded. It would give them a better opportunity to reach their job goal. So in those cases, even though there's medical improvement, cash benefits can continue until that program is completed.
Well, then, let me ask you this question. 2 days ago, a lady walked into my office. She's 60 years old. Her disability is schizoaffective disorder. She has been on regular Social Security or Title II for at least 10 or 15 years. She's been volunteering, and now the place where she's been volunteering has offered her a permanent half-time job. She came into my office and asked me that question: what are the risks? And I pretty much said things similar to what you said in terms of the insurance, the Medicare, the reinstatement right within 60 months, and then be able to get on pay status for 6 months immediately. This is a situation where there isn't any medical improvement, but is there anything you can add, using this as an example, to what you just said? I guess one question that jumps out at me is, we don't have tickets yet in California. When someone gets a ticket, they won't get continuing disability reviews. And how do they know there's medical improvement if they don't? In other words, with her, she's improved so she can work, but you never know, in 6 months, maybe she won't be improved. So I'm just wondering how that fits in. And if you can think of any other risks that maybe I should have told her, or people should be told, please, answer that as best you can.
Well, first of all, in that particular example, and it really is more specific to that situation, if she's 60 years old, she's going to be, if she went to work and her benefits stopped because of disability, she would be able to get retirement benefits at 62. They'd be somewhat reduced, but if, say, her 5 year, she went through her trial work period and her extended period of eligibility, which together is almost 4 years, she'd be close to 65, and at 65 she could get full retirement benefits, which is the same as disability. But of course that just applies to somebody in that age group. medical reviews are done on an ongoing basis. Sometimes they're every 3 years, sometimes they're longer. In some cases, they're within a year after the first decision as far as eligibility. But after that, usually they're 3 to 7 years. So that's just something that's routinely done, and working does not affect that. Those will be continue to be done. And I think Cal's going to talk more later about how the ticket affects medical reviews and returning to work. So I think that talk about that a little bit more with the ticket legislation.
Are there any other answers you can think of? Again, question's the same. What are the risks? Let's assume the person's 50, just for the purpose of the question. Have we covered the basics? We've covered the insurance. We've covered the amount of time that people can be reinstated. We've talked about 9 months for a trial work period, which they can actually keep their checks.
Actually, the extended period of eligibility starts the month after the month that the trial work period is over. They may continue to get benefits for the first 3 months, but when you're counting the 36 months, you count with the month after the 9th month of the trial work period.
Okay, so we would add 2 months. That'd really be the 11th month before we add the start counting 36. Am I saying that right?
No, it actually would start with the next month. So if April 2002 was the 9th month, May 2002 would begin the 36 months. You could receive a check in May, June, and July, but when you're counting the 36 months, you start with May.
Based on my experience, a really common situation is either losing evidence or not remembering the name of the person you talked to in the office. It really comes up all the time, at least at the hearing level before the judge. And I would caution people to send things certified mail, get acknowledgments on receipts, and if you talk to a person face to face, get the full name, bring in paper, don't be shy, and have the person give you something in writing that you reported. Because the issue of did you report or not is something which we come up against, at least at the hearing level, before the administrative law judge over and over again. You say you report and there's nothing in the computer that verifies that. And then we end up saying, well, what did the person look like who you talked to? So is there any other suggestions, in addition to what I just said about getting receipts, certified mail, and other documentation if you are going to go into the office? Is there anything else that you would recommend just to cover that problem that we come up against over and over again?
No, I think those are all good ideas. And it's helpful too, because if they need to call back and ask questions, they know who they talked to initially. And so they might want to get a phone number also.
I'm now going to introduce Michael Mundy, who's going to talk about the SSI work incentive programs. Remember that SSI is a poverty program, which in addition to medical disability requirements, there are income and resource eligibility requirements to remain eligible or on the SSI or Title 16 program. Mr. Mundy?
Thank you. And to that I would like to add that 80% of SSI recipients are eligible based on disability. 20% are eligible because they're over 65 years old. And I'd like to say that last year, 6%, only 6% of all SSI recipients were working. And that's a number that everybody would like to see increase. Now, let's talk about somebody going to work. If an SSI recipient starts working, it is very likely that the SSI monthly check will be reduced. As you said, it's a low-income program. Person is working and making money. That income has to count against the SSI check because of the nature of the program. Many of the Social Security's employment supports focus their attention on this particular issue, trying in some fashion to minimize the amount of the SSI check reduction due to work and thereby give a financial incentive for someone who wants to start working. So if somebody reports that they're making a monthly amount, certain monthly amount, what the claims representative will do is take that information and put it into the computer. And normally this will reduce somebody's SSI check. And the basic calculation, somewhat simplified, is that the gross monthly wages minus $65 write-off divided by 2. The result divided by 2. That will be the amount of the reduction.
So, for example, if someone gets a check of $750 per month, and then you subtract 65, and then they could actually make $1,565 and still be on the rolls?
It comes out to that very closely. My mental math abilities aren't that good. I can't do that in my head. But it comes out very close, yes, to double the amount of the check, you know. And then, you know, with the $65 calculated in, yes, somebody could earn quite a bit of money.
So this is actually a very important work incentive program where somebody could make almost enough to live on, actually, $1,500 a month, and not really have to be too concerned that they're going to be just cut off the rolls and back out on the streets. And that is 2 for 1. For every $2 you earn, you will lose $1 of your monthly check, generally speaking.
That's right.
So then they don't have to worry, correct me if I'm wrong, that, let's say, I think last year the SGA level was actually $740. We just said, I know we're using round numbers, if someone was making $750, given the 2 for 1, you can earn $2 and they'll only subtract 1 from your check. The Social Security Administration wouldn't say, well, now you're over 740, you're doing substantial gainful activity, you're working, you're not disabled. That's not going to happen.
Not if we're talking about the SSI program.
On the SSI program,
Right,
absolutely.
Right. Impairment-related work expenses, they were mentioned by Marilyn. Impairment-related work expenses will reduce the amount of countable income against your check. You can recoup some of the.
What do you mean by countable? What's countable?
Well, you know,
uncountable?
we did that little calculation. We took your gross monthly wages, and then, as we were saying before in the earlier section, for a lot of people, as maybe even most folks, big concern is their medical insurance. And if you're receiving SSI, you're also receiving Medi-Cal. That's a Medicaid program, Medi-Cal in the state of California. And I would say under most circumstances, somebody SSI eligible, going back to work, they start to earn money, their SSI check starts to go down, and even after it shuts off completely, they will continue to be eligible for Medi-Cal benefits, even if they're receiving 0 SSI.
Oh, even if it's 0, that could go on indefinitely.
Right. After a period of time, somebody gets a nice job and they start getting pretty good wages. There is a certain cap. It's pretty high. I don't remember exactly what it is. It's around $25,000 a year. Okay, I'd like to continue and talk a little bit about Social Security's PASS program. Social Security has one program that involves Social Security spending extra money on a claimant's vocational goal. It's called the Plan for Achieving Self-Support Program, PASS for short. By way of background, there's a network of regional PASS units throughout the United States handling this specialized caseload. In California, there are units in Chico, Sacramento, San Francisco, Anaheim, and San Diego. And basically, what the PASS involves is under an approved plan, a person can set aside income and or resources for a specified time for a work goal. So this is a direct monetary incentive for somebody to be able to afford to pursue a work goal. It's important to realize, however, there is no separate PASS fund. So we aren't able to actually send somebody money that's labeled PASS money. The PASS program is funded and is utilizing the person's own income. So if you have somebody who's receiving two checks, SSDI and SSI, the Social Security SSDI check is reducing the person's SSI check. With an approved pass in place, the Social Security income is excluded from counting against the SSI, and this has the effect of increasing the SSI check, and it frees up the Social Security income to be used for the person's goal. I know this is complicated, and it takes some people 2 or 3 times going through this.
Maybe it's worth just restating, because
Yes.
it's complicated, but it's sort of important. In other words, what you're saying is that the SSI program is a poverty program, and if you're getting a check for regular Social Security, SSDI, or Title II, they're going to subtract that money from the SSI to determine how much the SSI is. For example, if you get $700 for SSI and you get $400 from regular Social Security, SSDI, your SSI check will be $300, approximately.
Yeah,
I'm not
that's
saying
correct.
this, but is that
That's
basically
correct.
how it works?
Right.
The offset?
The SSI rate in California is $750, and if your Social Security check is $500, yes, then you get enough income when you add both your checks together to come up to the $750 rate.
So under the PASS plan, you can take the regular Social Security check, let's say it's $550, and through the plan, which Mr. Mundy will be talking more about, it won't be offset because it'll be used towards the vocational goal, and then you can get your full $750. Am I stating that right?
Yes, that's correct. That's correct.
Okay.
Now, I think you can see from this that somebody who is only receiving SSI, we can't do this sort of calculation with. So somebody who only receives SSI normally would not be eligible for a pass, just because of the way it's set up. We can't exclude, something if they don't have anything to exclude.
You may have misspoke. You didn't mean wouldn't be eligible for a pass. You mean for an offset.
Well, yeah, but in essence that means a pass, doesn't it? Because if
I
you're
don't know, does it?
yeah, your SSI, if you're only receiving SSI, and if the way the pass works is by excluding some other income that you might have, and if you don't have any other income, then the pass might not be for you. Not that you couldn't contact the Department of Rehabilitation, but we wouldn't be able to work our exclusions. We wouldn't be able to go into the computer and exclude anything.
If there wasn't anything
There wasn't anything to
obviously.
exclude, yeah.
Right.
So
How
just
do the people know of the PASS program? The SSI recipients, it seems to me that, well, we know it obviously, but how does the person that they get on SSI, they're disabled, they don't have enough income or resources, so they qualify. How do they find out? Does somebody tell them?
No, that's a good question, and we think that not enough people do know about it, and we've been trying to mount a concerted public relations campaign and to let people know about it. We have some very nice, colorful posters that we're putting up in the district offices, and there's periodically, I suppose, check stuffers that go out, and we're trying to also educate the various departments of rehabilitation in our area as to the existence of this program, so they can tell their clients. We're in touch with the various independent living centers, things of that nature. We're trying to get the word out.
What would you describe as the profile of a person who's in a PASS program? Like just the average profile.
The average profile is somebody who wants to go back to work and is quite likely has had some contact with the State Department of Rehabilitation with an actual job counselor, and they've sat down and gone over and picked out what's a realistic job goal for that person. And in this situation where the state has maybe is approved a job goal, but there's still some funds that need to be put into place. And I'd say that probably is the typical person, not that our clients are all with the Department of Rehabilitation, but typically they are. And therefore, we can fund some items for them that maybe the state can't or would be difficult for the state to fund.
What are some examples of past plans? In other words, are they mostly people who want to be practical nurses or computer technicians, or what is?
I can't generalize. There's just about everything. There's somebody who wants to become a better home chore worker. There's somebody who wants to become a lawyer. There's somebody who wants to become a PhD at UC Berkeley in the physical sciences. And we have people who are becoming janitorial service. So it just goes the whole gamut.
So if someone, to use something you just mentioned, and it sounds very broad and flexible from what you said, that is the gambit of the plans to achieve self-support. If someone was going to start a janitorial service and they got a $50,000 settlement from their workers' compensation case, just as a starter, a little seed money, let's call it, for the purpose of this question, to start the janitorial service, and they're on SSI. There is no workers' compensation case at this point. Could they take the $50,000, at least in theory, and segregate this to be used for their new business that they're planning?
The answer is yes, they could. Remember, you can, under the PASS, you can set aside either income or assets. And so, although it's not very common, in other words, somebody with an inheritance or a settlement and who was receiving SSI and had a work goal, a specified work goal, and met all the other conditions, yes, it certainly would be possible.
I guess a frequent question that I get asked, and it has to do with resources, is people on SSI, somehow the Social Security Administration discovers assets, whether it's life insurance or whether it's bonds or whether it's real estate in Costa Rica. This situation is actually very common, and it is a resource, an excess resource that can turn into an overpayment case. But keeping this in context, the person is really interested in the PASS plan. Does it matter that this resource was in existence for the whole time they've been on SSI for 15 years and just didn't know it? I mean, could they then put it in, or is it more complicated?
Right. Well, you know, it's like there's a lot of different questions going on here. There's the existence of unknown assets, which usually we don't count anyway. You know, or it could be, you know, how can we count an asset if the person doesn't know about it? So that's an out.
They don't count it towards
That's
what?
an out. Towards the asset, towards the resource limit.
It's interesting to hear that, because I guess over the years it seems to
it
be
has to
so
be
common.
Yeah, it has to be shown that the person really was unknown, and it really was unknown. That might be difficult.
What do they do if it's not counted? What do you tell them to do? Spend it? How do they get rid of it?
It depends, you know, on how much it is, and to be honest, we aren't in the position of being financial advisors to somebody. But if, when I was a claims representative and somebody had you know, assets or an inheritance or something, my advice was don't blow it. You have the opportunity to do something with this money, do something with it. Not necessarily a pass, but they can, you know, pay rent, they can buy a mobile home, they can stabilize their situation in some way.
How long do they have to do any one of those alternatives?
Well, if it's a inheritance out of the blue, it's, you know,
or a bond or a security or something out of the blue.
Income in the month received and an asset the month thereafter. If it's retroactive Social Security money, they have a 6-month window.
Okay, but otherwise, that if someone, and they didn't know about the asset, because this has happened to me, I can't tell you how many times, bonds, life insurance, real estate. Marilyn, they have a month to get rid of it, change title if it's a security, or sell it? Is that what you...
Yeah, just to clarify, it is not an asset it's income in the month that it's discovered, because it's just like they were receiving it in that month if they didn't know about it previously. So if it's an inheritance they get in that month, or they discover they had some savings bonds that grandma had left for them, or whatever it is in the month that it's discovered or it's received, it's income, and then the next month.
How long does it take, and I think you sort of touched on this, to get a pass?
Well, from the time that you drop off the application,
Correct. Once
Yeah.
they know about it, of course,
uh-huh.
and then fill out the application
Right,
form.
right.
What are we talking about here?
Well, we are always asked that question, and we always have to give general answers.
That's all.
Okay,
I
it can
couldn't
take,
answer
it could take for a fairly simple pass that was brought to our attention by the Department of Rehabilitation. It was a very simple, clear cut. It would only take maybe a few weeks for it to be approved. But other plans, other issues involved, self-employment, much more complicated, that could take a matter of months. Now I want to go over just a few of the really basic ground rules, just real basic.
Yes.
Okay, pass, you have to show a specific occupational goal. So it needs to be an actual job in the economy. Okay. It has to transpire within a reasonable time frame. So, you know, whatever that might be, that's a judgmental thing, but it has to be a reasonable time frame. It can't be just open-ended. It has to have beginning date and an ending date. You know, we have to know what the ending date is.
Right, and is that subject to modification over time?
Sure, of course, of course.
Okay.
You know, things like that can happen. And then the next thing, and the last thing I'm going to say is a person has to actually be able to spell out what they want the pass to cover. List of the items that the pass is going to cover, whether it be tuition or a computer or whatever, something like that, specific items needed. Remember, each person is going to have a different amount of income to put into the pass, because each person's Social Security check is different. Each person's other income, excludable income or resources is going to be different. Therefore, the amounts is going to be different, and the things that they can afford are going to be different. So those are the things we need that should be in writing. There is a form. There's a pass application form. People could pick that up at their local Social Security office.
Up till now, we've been talking about Title II of the Social Security Act, commonly known as SSDI, Disability Work Incentive Programs, and also Title 16 of the Social Security Act, commonly known as SSI, Disability Work Incentive Programs. Effective January 1st, 2001, the Ticket to Work and Work Incentives Improvements Act became effective. Congress enacted this legislation as a work incentive in that they determined, based on studies and through testimony, that most people were afraid to engage in work activity for fear of losing their health insurance. For people on Title II or SSDI, that's Medicare, and for people on SSI, the poverty program, that's Medicaid or Medi-Cal. So in major part, this legislation alleviates that fear, because people can continue receiving their Medicare if they're working under a ticket to work for an additional period of time, specifically an additional 4.5 years over the initial extended period of eligibility, which was 36 months, and do not have to worry about losing their health insurance. Even after they've been at work for many years and become self-sufficient, there's a provision that they can buy into Medicare and not have to worry about foregoing health insurance. There's also another provision in the Ticket to Work legislation, which has been in full force and effect since January 1st, 2001, in which an individual can be reinstated and receive their Medicare if they were terminated or ceased within the prior 5 years or 60 months. And that reinstatement would immediately put them on Medicare. It's called an expedited reinstatement. In other words, if something went wrong and they could no longer wait, they would not have to go through a reapplication process. They could immediately get their Medicare back. And this is the underlying focus of the Ticket to Work legislation, based upon findings by Congress, which are stated in the legislation, specifically that people do not want to make work attempts for fear of losing their health insurance. One of the primary work incentives in the Ticket to Work legislation is that the Social Security Administration will not do continuing disability reviews, which they have been doing for the last 20 years. So people don't have to worry about getting a notice or being pulled in by the administration and being sent to a doctor on contract with the Social Security Administration and have any fear they will be terminated from benefits. This is a very substantial part of the Ticket to Work legislation, which should encourage people to go out there and attempt to work, because if they don't use the ticket, they are still going to be subject to being re-examined by doctors every 3 to 7 years. In the new Ticket to Work legislation and implementing regulations, outreach and other informational programs are established nationwide. Contracts have been given to Protection and Advocacy, which is a national organization in Northern California. They have an office in Oakland. Other outreach and informational agencies include ILRCs, which stands for Independent Living Resource Centers. In some cities, they're called Center for Independent Living. However, they are federally funded, and they are charged with giving information and outreach on work incentive programs. There is also another layer of informational agencies set up nationwide called Benefits Planning and Outreach Offices, for short BPAO. Now, these offices are charged with giving out information on a variety of work incentive programs, including Ticket to Work information, pass information, and other information relating to work incentive programs discussed here. In addition to these, your local Social Security field office has information. We recommend, at least the panel recommends, that the office that is the least busiest or has the shortest line is the one to go to in general. In other words, to go to the BPAO, or Benefits Planning and Outreach Office, to get information on a PASS program may be much less efficient than contacting a PASS unit itself. There are 5 PASS units in the state of California. In other words, although any and all of these agencies or avenues are available to get information on work incentive programs, the one to go to is the one that can help you in the most expeditious way or with the shortest line. So you can start out always by calling your local Social Security office and getting the phone numbers for other contractors, including the Independent Living Resource Center, Protection and Advocacy. The ticket in the Ticket to Work legislation, in essence, is a mechanism by which a disabled individual can enter into a contract with an employment network. Employment networks are private organizations that will be paid in different ways, but primarily upon successful placement of the disabled person in a job. Therefore, they do not have to accept any disabled person on Social Security benefits. They are interested in interviewing people because if the person is successful in completing a plan, a vocational plan, and then placed in a job, they will be paid, as opposed to being paid whether or not the individual is placed. If the employment network does not wish to work with an individual, which is very likely in people who have severe disabilities, especially severe psychiatric disabilities, because it is the profit motive at work here, and they would want to minimize their risk. However, these people can still go to state vocational rehabilitation agencies, which basically can provide the same services. And some states, in addition to the private companies, are named employment networks by the Social Security Administration. The full implementation of the tickets in all 50 states is supposed to be fully completed by the year 2004. There are alternatives to employment networks. An example is a state vocational rehabilitation agency, but it may be important to still go through the ticket procedures so as not to lose any health insurance or other medical coverage. We thank the panel members who are employees of the Social Security Administration for their help and assistance, and this will conclude the program. For further information, feel free to contact the Social Security Administration's webpage at www.ssa.gov, or the People with Disabilities Foundation, which is headquartered in San Francisco, California. Our web address is www.peoplewithdisabilities.org, O-R-G.